Good afternoon, everyone. My name is Steve Neely. I'm a commercial litigation partner in Husch Blackwell's Washington, D.C. office, and I'm joined today by Kayla Foley, an attorney in our Chicago office. We're excited to be talking to you today about protecting privilege, tips for identifying and safeguarding privileged communications. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We truly appreciate your audience participation, and we encourage you to submit questions at any time. There's also an icon to assist you with your viewing preferences. Accordingly, please note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area, or by dragging the bottom right corner of the slide area. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck and additional materials are available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for continuing legal education credit in Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, and Texas. Virginia and Wisconsin credit is pending. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. And that wraps up the housekeeping. I'll now turn it over to Kayla, who will get us started. Kayla?
Thanks, Steve. Hello, everyone. My name is Kayla Foley. I'm an associate in Husch Blackwell's Chicago office. This afternoon, my colleagues Steve and I are going to be discussing privilege. I will start off this webinar pretty broad in regards to privileged communications. I'll start off covering some common misconceptions regarding privilege, and then cover a few types of privileges, including attorney-client, the work product doctrine, and the Kovel doctrine, which is a derivative privilege. Steve will then discuss additional derivative privileges, including functional equivalence, joint defense, and common interest, and the self-critical analysis. He'll also cover tips for protecting privileges and tips for privilege review. So first, there are a lot of ideas and myths, you could call them, with regards to what privilege really means and what types of communications are really covered by privilege. For example, despite common misperceptions, the attorney-client privilege does not automatically protect communications simply because a lawyer participated in them. The privilege only protects communications primarily motivated by a client's request for legal advice from a lawyer. The emphasis is on the legal advice. We will get to exactly what these privileges require later on, but first we're going to break down some of these myths so that you really understand what is privileged and what is not privileged. The thing to remember is that communication will generally be privileged if the primary purpose of the communication was to obtain legal advice. Myth number one, labeling a document privileged assures the protection. Labeling something privileged does not make it privileged. Whether the document will be privileged depends on whether the communication within that document is for the purposes of obtaining or receiving legal advice. If that is not the case, there are no magic words or no rubber stamp that will transform an everyday communication, whether it's sensitive or not, into a privileged communication. Myth number two, a lawyer's participation in a meeting will extend privilege protection to the meeting's communications. This is also not true. The mere fact that an attorney attended a meeting does not render everything that was said or everything that was done in that meeting privileged. Myth number three. As we touched on earlier, business advice from a lawyer, especially in-house counsel, may not be considered privileged. There's a heightened scrutiny for in-house counsel. Unfortunately, for in-house counsel in particular, the line between business advice and legal advice can appear blurry. The harsh reality is that in-house communications are evaluated more rigorously to determine whether the attorney, the in-house counsel, was in fact providing legal advice. Some courts even start from a presumption, implicit or explicit, that communications with in-house counsel are for a business, not a legal purpose, and therefore the communications are not privileged. Courts that apply this heightened scrutiny with in-house counsel often opine that when legal and business purposes of the communications are intertwined, the communication is privileged only if the legal purpose is predominant or outweighs the business purpose. Several courts often require that in-house counsel make a clear showing that communications were made for a legal rather than a business purpose. In addition, in-house counsel has to take note of their title, especially in emails. This is because in-house lawyers with both law and legal department and then also business department titles will find it nearly impossible to successfully claim privilege protection for communications when they're undertaken in the business title role. I just want to discuss one example of this, a case where the line between business advice and legal advice can be blurry. In Paranos versus Barnes & Noble, Inc., the CFO of Barnes & Noble informed the company's general counsel that a female employee who served as an executive assistant had reported to him that the CEO sexually harassed her and made her feel uncomfortable. The GC met with the executive assistant, where he took notes during the meeting, and he also drafted a memo summarizing the meeting. He asserted that he had prepared these notes so that he could render legal advice to the company regarding the company's rights and the company's obligations with respect to the alleged conduct with the assistant. Then that same day, the GC engaged outside counsel. Once litigation ensued, the plaintiff, the CEO, accused of misconduct, argued that the investigation documents were not privileged because they were created for business purposes, not legal purposes. His basis for asserting this was because the employee handbook required that the complaint be investigated, and thus the notes were for a business purpose. The court disagreed in this case. The fact that the company's top executive, the CEO, was being accused of potentially serious misconduct provided circumstantial evidence to support the claim that the purpose in conducting the investigation was to provide the company legal advice. In addition, the retention of outside litigation counsel to advise an internal investigation was another important factor in determining whether an internal investigation was being conducted for the purposes of obtaining legal advice for the company. So the moral of that case is that in-house counsel has to make the justification for his work very explicit. Here, the GC took the right steps in this situation to ensure that the work product was protected because it was for the purposes of obtaining legal advice for the company, and he also hired litigation counsel that same day. The last myth I'll cover is that copying a lawyer on a document also assures the protection. Many people believe if they simply include a lawyer as a recipient of the email, then the contents of that email will be privileged. This is not true. The communication itself still needs to meet the test of asking for or providing legal advice. This is especially true and becomes important when communicating with in-house counsel. For example, an employee may email another employee discussing some sort of business decision, and they might copy in-house counsel on that email. And they might do this for a number of reasons, but one of those reasons may be to keep in-house counsel in the loop in the event legal advice is needed, or simply because counsel is acting in a business advisor role. However, this line can be difficult to draw because obviously in-house counsel does give both legal and business advice. So an employee may be emailing another employee, and the contents of that email may include both legal matters and business matters. The employee should not assume that this entire email would be a privileged conversation just because it does include some legal matters. The safer course actually is to assume that the communication will not be privileged unless the subject and substance both plainly concern legal advice and only legal advice. If the communication addresses both legal and business issues, the portion that relates to legal advice should be privileged, but there is a risk of losing it if there's a mixed communication, because the court could find that the primary purpose of the communication was to obtain business advice, not to obtain legal advice. Some courts have strongly criticized in-house lawyers' efforts to seek privilege protection by artificially involving themselves in their corporate clients' internal communications. Here's an actual fact pattern from a case to show how this works in practice, and also an example of what not to do. General counsel for a company instructed all of his employees to copy him as a recipient on any email or any document, any and all emails or any and all documents to assure that attorney-client privilege would be retained. As you can guess, the court did not find this was an appropriate way to retain the protections of the attorney-client privilege. The court stated, quote, "The mere presence of a lawyer's name at the top or bottom of a document is not the bell that causes the dog name privilege to salivate. What is entitled to protection is really limited to the communication of confidences from client to lawyer, whether any such communication is disclosed in a client-authored document or a lawyer-authored document." So now we're going to shift gears and discuss two of the most important privileges, the most relevant as well. The first privilege I'll cover is the attorney-client privilege. The attorney-client privilege protects 1, confidential communications, 2, between an attorney and client, and 3, made for the purposes of obtaining legal advice. So unless all 3 of these prongs are met, the communication most likely will not be privileged. So the first prong is confidential communications. In order for a communication in any form to be confidential, both parties to the conversation must take reasonable steps to ensure confidentiality. For example, clients who speak to their attorneys about a pending lawsuit in private with no one else present can reasonably expect confidentiality. But a client who speaks to a lawyer in public wouldn't be able to prevent anyone who had overheard the conversation from later testifying about it, and that would destroy confidentiality. The next prong is that the confidential communication must be between an attorney and client. There are 3 categories of who can be a privileged person to meet this second prong: the client or prospective client, 2, the lawyer, and 3, the agents of the client or agents of the lawyer. To be privileged, both the person sending and the person receiving the communication must fit within one of these 3 categories, so they must be a privileged person. If either the communicating or receiving party is not a privileged person, then the communication is not protected. For example, if a lawyer is not acting in his professional capacity, rather as a friend, then the communication cannot be said to be between an attorney and a client because the attorney was not one as a privileged person for that encounter. Comments addressed to third parties do not come within the privilege. For example, the presence of a close friend in a meeting with the lawyer may destroy the privilege. The privilege does not apply to communications from third parties to a client either, if they are later communicated to the attorney by the client. Also, as a note, agents of the client can be a privileged person. It's not just limited to attorneys and clients. We will discuss that shortly. The last prong, number 3, made for the purposes of obtaining legal advice. This arguably is the most important. Communications created independent of the process of seeking legal advice are not privileged and will be a fair game for discovery. For example, a client emails his file of recent business decisions he made. He sends it on to his lawyer. This would not be for the purposes of obtaining any legal advice and would not be covered under the attorney-client privilege. So in analyzing attorney-client privilege protection, content is king. Courts will almost always look to the content of the communications in determining whether it falls under the protection. Thus, given the content-based nature, courts usually analyze each pertinent communication separately. Each email, each document will be analyzed separately to determine whether it falls under attorney-client privilege. The privilege will almost always apply to requests for legal advice from a client to an attorney, requests for information from an attorney for information needed to formulate or provide legal advice, and the legal advice given by the attorney. Also, always remember that the attorney-client privilege may be waived. The privilege does not apply to information that's shared with third parties or, as I mentioned, the people that aren't considered privileged persons. When that happens, the privilege would be waived. Also note that the privilege belongs to the client, which means that the client may elect to disclose the information at any time for any reason. I'll give a hypothetical that should be helpful. Let's say company senior vice president Jim asks company's in-house counsel Sarah a question about the legal requirements of merging 2 subsidiaries of the company. In a responsive email, Sarah provides legal advice in response to the question and recommends a course of action. So this email would constitute confidential communications between a client, Jim, and his lawyer, Sarah. Although merging two subsidiaries may involve business advice, Jim is clearly asking for legal advice from Sarah, and the email would be protected by the attorney-client privilege. Let me go back. Okay, so let's add one more set of facts to that scenario. Let's say Jim forwards Sarah's email to his banking contact to let his banking contact know that changes to the subsidiary's accounts will be forthcoming. Has Jim waived his privilege, yes or no? In this case, Jim, yes, has likely waived this privilege. Jim could have achieved his objective and avoided the waiver by simply advising the banking contact that changes will be forthcoming without forwarding or summarizing the legal advice from the in-house counsel, Sarah, or even explaining the reasons for these changes. There was a better way to do it. There are also a lot of items that the attorney-client privilege does not cover, and these are pretty important to know as well. The privilege will not protect the fact that an attorney-client relationship exists. It will not protect the client's identity. It will not protect basic logistical details about an attorney-client relationship. For example, these logistical details could include the date of a client referral, the length of time the lawyer has represented the client, the identity of a non-client who retained and paid the lawyer. If a family member pays the lawyer, it's not privileged that the family member did that. Or the fact that a client has contacted the lawyer at all. These usually will not be covered by the attorney-client privilege. The privilege also does not protect retainer agreements. However, it is possible that a portion of the retainer agreement might deserve protection if it specifically describes what the client has requested the lawyer to do or what the lawyer proposes to do. If it's not just standard boilerplate language and it's about legal advice, then these could be redacted. The privilege usually does not protect general information about the lawyer's fees, including who paid the fee or the lawyer's hourly rate. However, similar to retainer agreements, portions usually can deserve privilege protections. They can be redacted if they do involve legal advice or mental impressions of the attorney, which bills usually will. All right, the next privilege I will cover is the work product doctrine. The attorney work product privilege protects from disclosure to third parties any materials that are prepared by or for a party or its representative motivated by or in anticipation of litigation. The work product doctrine is a valuable means of protecting confidential documents. While the work product doctrine does shield an attorney's mental impressions, an attorney's opinions and their conclusions from opposing counsel and from the discovery process, the work product doctrine is not a privilege such as like the attorney-client communication is. Rather, work product is given qualified protection from discovery as a concession to the necessities of the adversary system. As the Supreme Court established in Hickman, the work product doctrine is not absolute. This protection is not absolute, and discovery can be permitted if the party seeking the certain documents, if they can establish adequate reasons, such as substantial need and undue hardship. To qualify for work product protections, courts hold that the items must be documents or tangible things prepared by or for a party and prepared in anticipation of litigation or for trial. Although the rule literally applies only to tangible things, it is clear that the work product protection extends to both tangible and intangible work. It's important to note that the attorney-client privilege protects communications between a client and a lawyer relating to all kinds of legal services, while the work product doctrine protects only litigation-related materials. So earlier I said that content is king when analyzing attorney-client privilege. When analyzing the work product doctrine, context is king. That is because the work doctrine must be prepared in anticipation of litigation. So it's important to know when, in what context, the work product was created. All right. To establish that a document was prepared for in anticipation of litigation, a party must demonstrate that the threat of litigation was impending. A general fear of ever-present litigation in the future will not meet this requirement. Bare assertions in contracts indicating the possibility of litigation will not automatically entitle documents to work product protection either. But note that documents prepared after a litigation hold is put in place will generally be protected. Some courts de-emphasize the time requirement of imminence and focus on the motivation behind creating the allegedly protected material. For those courts, the party has the burden of demonstrating that use in litigation was the motivation underlying the preparation of the document subject to a claim of work product protection. Regardless of the particular degree of litigation-related motivation that courts may require, virtually all courts require that materials that are created in the ordinary course of business or pursuant to public requirements unrelated to litigation are not protected. For example, a surveillance video that captured plaintiffs' slip and fall will not be work product because it was created during the ordinary course of business. Attorney billing records are an example of an ordinary business record, but they may nevertheless be protected by the work product doctrine. As I mentioned before, the narratives in attorneys' bills usually they can be undertaken in anticipation of litigation and definitely can fall under the attorney-client or the work product doctrine protection. Courts are split on the degree of motivation that a party must show to establish that a document was prepared for in anticipation of litigation. The Second, Third, Fourth, Eighth, Ninth, and DC circuits find that a document will be protected if it was prepared because of the prospect of litigation. The Fifth and Seventh circuits conclude that preparation for litigation must be the primary motivating factor underlying the creation of the document, and the First Circuit has adopted an even narrower for use in litigation test. Another hypothetical, assume company X is faced with an important business decision. It must decide whether to merge two of its wholly owned subsidiaries. The contemplated merger will result in losses of hundreds of millions of dollars, which will in turn generate a tax refund of tens of millions of dollars. Because of the tax consequences of this merger, the Company Act knows that the IRS will challenge the tax treatment and they'll probably end up in litigation. So to help determine whether to proceed with the merger, Company X wants to hire an outside consultant, an individual who is a lawyer and an accountant, and they want the consultant to evaluate the risks of the litigation. Would the outside consultant's work be covered by this attorney-client privilege? The answer is yes. These are the facts of U.S. versus Aldman. This is a Second Circuit case. In that case, the outside consultant drafted a 68-page report which contained the discussion of statutes, regulations, and evaluated challenges that the IRS would most likely bring. It set forth methods of structuring the transaction and made some predictions about the outcome. In discovery, the IRS tried to obtain the report, and the Second Circuit held that it did fall under the work product protection. That, quote, a document created because of anticipated litigation, which tends to reveal mental impressions, conclusions, opinions, or theories, it does not lose work product protection merely because it intended to assist in the making of a business decision influenced by the likely outcome of the anticipated litigation. Now we'll discuss derivative privileges, which are not separate privileges, but rather an extension of the attorney-client or the work product doctrine. I'll start off by discussing the Kovel doctrine, which again, not a privilege in and of itself, but rather a derivative privilege. As I mentioned earlier, in addition to clients and lawyers, the definition of privileged persons covered under the attorney-client privilege may also include agents of the client and agents of the lawyer who assist in the representation. So the Kovel doctrine describes the parameters for the extension of the attorney-client privilege to non-attorney third parties. Pursuant to what has become known as the Kovel doctrine, a consulting expert retained by the attorney or client to assist the attorney in providing legal advice to the client can qualify as a privilege agent if consulted for the purposes of improving the attorney's comprehension of factual information or the client's comprehension of legal advice. The case where this doctrine derived from is United States v. Kovel. It's a case from the Second Circuit Court of Appeals. The Kovel doctrine has been adopted by most circuits now, and it's been applied far beyond the factual context of the case itself. It now informs how courts evaluate the privilege for non-attorney third parties. So I'll briefly talk about the facts of the case. In Kovel, Kovel was a former IRS agent. He was employed by a law firm that specialized in tax law, and he helped the lawyers at that firm with his expertise in tax accounting and client representation. So a grand jury in the Southern District of New York was investigating alleged tax violations by a client of the law firm, and they subpoenaed Kovel. The law firm advised U.S. attorneys that Kovel was an employee under the direct supervision of lawyers, and he would not be answering their questions. The U.S. attorneys disagreed. They insisted that the attorney-client privilege would not extend to Kovel, as he was only an accountant and not a lawyer. And Kovel was sentenced to prison because he refused to answer questions in court about discussions he had had with the firm's client during the grand jury. So the court held that the attorney-client privilege could extend to communications between a client and a non-attorney third party if the communication is made in confidence for the purpose of obtaining legal advice from the lawyer. The privilege should be extended to protect communications which were necessary to discussions between the client, or at least highly useful to discussions between the client and the attorney. So the privilege can be extended to cover communications when a consultant or an expert plays a translating or an interpreting function, because it really helps the attorney better understand and convey information, and usually can be used to help the client understand what legal advice they are getting as well. So in the Kovel case, the court thought of Kovel as a translator to better assist the attorneys in representing their client against the claims of tax violations. Remember again that the extension of the privilege heavily depends on the purpose of the advice conveyed. The standard set forth in Kovel has been applied in a number of cases addressing various types of translating experts. It has been applied to facts where the financial advisor is the translating expert. Courts will scrutinize whether the banks or financial advisors are acting to further the business interest of the company or to assist the lawyer by playing a translating role. So if the financial advisor is playing a translating role to help the attorneys give advice to their clients, it can help ensure the communications are privileged. In one case in a New York District Court, the court explained that simply because financial consultants are employed to assist a company in restructuring a transaction does not mean that their communications with the attorneys were made in confidence for the purposes of the client obtaining legal advice from counsel. So you still have to keep in mind that there's a heightened scrutiny on these communications. Not everything an outside consultant will say or advice he will give will be covered under the Kovel doctrine. An example that courts haven't really gotten behind is PR firms. Under Kovel, courts are less likely to extend the privileged communications with PR firms. They don't tend to think that the PR firm is really providing expertise or input really relevant to the legal matter. If the PR firm is not involved in legal strategy or helping facilitate the attorney's legal advice, he usually won't pass any muster. So a few tips for structuring third-party relationships in light of the Kovel doctrine. Since the doctrine requires a fact-intensive inquiry, counsel should carefully craft and control third-party relationships to demonstrate the legal necessity. You want to make sure that the court eventually down the road may understand that the third party was necessary to help facilitate advice to the client. Don't just assume hiring a consultant will automatically mean that the communications are privileged if they aren't truly helping the lawyer render legal advice. Also, retention by counsel rather than the client cuts in favor of finding that the agent was necessary to the representation. So carefully craft retention agreements for the third party, potentially structuring it such that the lawyer rather than the client retains the third party consultant, and specify the basis for that engagement. Ensure that any related communications from the third party are addressed to the lawyer rather than the client. That can help show that the lawyer, the consultant was helpful in rendering legal advice to the client, acting as that translator role. And now I'm going to have it go back to Steve, covering some more derivative privilege and helpful privilege tips.
Thanks, Kayla. So the next derivative privilege we're going to cover is related to the Kovel doctrine, and it's the functional equivalence privilege. As Kayla explained, the attorney-client privilege applies to communications between the client and the attorney or the client's agent, and disclosing the communication to a third party can destroy or waive the privilege. So that gives rise to the question, who's included within the definition of client or agent of the client? And the functional equivalence privilege provides an answer to that. To illustrate this, consider the following hypothetical, which also includes a polling question. A corporation acquires 4 commercial properties and hires a property management company to manage the properties. When the corporation later sues its tenants in unlawful detainer actions, the tenants subpoena documents from the property management company. The corporation objects and claims that the attorney-client privilege applies to communications between the corporation's lawyers and its property management company. Is the corporation correct? And we have a polling question here for yes or no. Give you a few seconds to chime in there. And we are about 50-50 split, which is interesting. The answer is potentially yes. The hypothetical that I've included here is from a recent Tennessee Supreme Court case, Dialysis Clinic versus Medley, in which the court held that communications with the property management company were privileged, even though that company was a third party. The court reasoned that the property management company was essentially the functional equivalent of the corporation's employees, and it was therefore within the privilege umbrella. The court noted that the company served a very specific role for Dialysis Clinic, and it was a role that the clinic could not do itself because they were not well-versed in property management. The court also noted that the property management company was directed by Dialysis Clinic to communicate with their attorneys for the purpose of legal advice, and everyone intended that those communications would be confidential. Although this is a recent example from a Tennessee state court opinion, the functional equivalence privilege has been recognized for some time at both the state and federal levels. The seminal case recognizing the privilege that you'll see cited very often is from the 8th Circuit in Ray Beater Company, which involved a very similar factual scenario to the one in Dialysis Clinic, and the court arrived at a very similar conclusion. So how do you determine whether a third party is the functional equivalent of an employee of your company, for example? There are generally 5 factors to consider. First, you look at whether the third party is performing a very specific role for the company. Is a role that the company can't otherwise do by itself or deliberately sends off to agents? Second, does the third party act as a representative for the company in interactions with others? Third, does the third party acquire information in that specific role that no one else has? If it does, the 4th factor is that third party authorized to communicate with the company's attorneys within the scope of its role and the information that it has? And then lastly, when those communications happen, are they intended to be treated confidentially? If those 5 factors are met, then the third party is potentially within the scope of the privilege, and the next step is to determine whether the communications are actually protected under either the attorney-client privilege or the work product doctrine using the analysis that Kayla outlined earlier. And just like communications involving the actual client, the privilege can extend to communications between the third party and either in-house counsel or out-house counsel. Lawyer's a lawyer regardless of who they work for, as long as they are representing the client. So let's try another hypothetical now that we've outlined the factors for the functional equivalence privilege. I'll outline the facts of the hypo, and then we have another polling question, but this time it's true-false. Multicare Health, a nonprofit corporation, operates a hospital, Big City General. It is also a part owner of another nonprofit corporation called Trauma Trust that provides trauma doctors to work in the ER at Big City General. The doctors of Trauma Trust are agents, but they're not employees of Multicare. One night, a drunk driver comes into Big City General in need of trauma services after sideswiping a parked car, hitting a power pole head-on, and going through the windshield. The hospital personnel end up disclosing the driver's blood alcohol level to law enforcement investigating the accident, and the driver later sued the hospital. So the question is, Multicare hired one firm to represent it, its employees, and the Trauma Trust doctor that treated the patient. The patient's lawyer objected to this. Multicare and the doctor objected to them having the same lawyer, so Multicare sought a protective order confirming that its communications with the doctor would be privileged because the doctor was the functional equivalent of a Multicare employee. The statement is, Multicare is entitled to a protective order. Do you think that's true or false? And the survey says 50-50 again. This time the answer is actually false, but not because of the facts, but because of the jurisdiction. This hypothetical is another real example from a recent case out of Washington State. But unlike Tennessee, Washington State has not recognized the functional equivalence privilege. Although they acknowledge in the case and the quote that I've provided there that the privilege has been recognized by several federal courts, they did not adopt that approach because the Washington Supreme Court has been hesitant to extend the attorney-client privilege too far in the corporate context. So the takeaway here is to make sure that you check your jurisdiction and ensure that it recognizes the functional equivalent privilege before allowing third parties to communicate freely with your attorney. The next derivative privilege is the joint defense or common interest privilege. It applies in scenarios where two or more parties that are represented by different attorneys share a common legal interest and have a need to share privileged information. The most common areas where this arises are in criminal cases involving co-defendants, in the insurance and indemnification context, where one party is assuming the defense of another, and in the patent law context, where multiple parties have an interest in patented technology. These are just some of the most common areas. The truth is we see the common interest privilege arise in a large number of scenarios in today's business world. But when these circumstances are present, the parties can share information without waiving privilege, and they can enforce the privilege against each other. So even if the relationship later sours and one of the parties wants to stop sharing information, they still cannot use or disclose the other party's privileged communications because the common interest privilege generally cannot be waived unilaterally. But just as it cannot be waived unilaterally, the common interest privilege also cannot be created unilaterally. You cannot simply share privileged information with a third party and then later claim it's privileged because you think you share a common interest with that party. All of the parties have to agree to the joint approach, ideally before you share any information, and then the information that is shared between the parties has to be intended to further the joint interest that they're collaborating on. The main thing is to ask whether the parties are engaged in a joint legal effort that requires or would benefit from the sharing of privileged information. If so, common interest privilege may apply. Most common interest arrangements also involve a written agreement where the parties expressly agree to share privileged information and to protect each other's information from disclosure to the parties. It is not an absolute requirement, but it is best practice. Like I see common interest this slide here includes an excerpt from a common interest agreement, and we've bolded the language that you can see clearly announces the parties' intent to enter into this agreement and to maintain all privileges over their communications. But a written agreement is not dispositive and it's not an automatic shield. A court may still look at the substance of the joint arrangement to see whether the parties actually were engaged in a joint effort. If they weren't, the fact that they signed a common interest agreement may not be enough to ensure the privileged nature of their communications. In this case here, King Drug Company of Florence from federal court in Pennsylvania, the parties signed a common interest agreement, but then did not actually share information with each other for nearly 2 years during the litigation that gave rise to the common interest agreement. They only started sharing the information when they got close to the settlement stage and started talking amongst themselves about how a potential settlement would affect the other parties. The court held that the lack of information sharing between the parties indicated that they weren't actually engaged in a joint defense, and the common interest privilege didn't apply, notwithstanding the existence of the written agreement. So if you have a common interest agreement and you're entering into that arrangement, make sure you're actually pursuing that arrangement and sharing information to further your joint effort. Well, one question that comes up frequently is whether corporate affiliates need to enter into common interest agreements in order to facilitate information sharing while maintaining privilege over their communications. For example, is an agreement necessary for the general counsel of the parent company to have a privileged communication with the employees of one of the parent company's affiliates? The answer is generally no. The trend is that disclosures between an affiliate and a parent company, at least a wholly owned affiliate, do not destroy privilege because the parent company and that wholly owned affiliate are treated as a single entity. It may be different in circumstances where the parent company owns only a partial interest in the company, or there are other owners of the affiliate company. But if the affiliate is wholly owned, they're treated as a single entity, and you do not need to worry about an official common interest agreement. This next derivative privilege is one of my favorites. The self-critical analysis privilege, or it's sometimes also called the self-evaluative privilege. I've included another example here, also again from a real case, but there's no poll this time. Just wanted to share the facts, which are these. A lobster fishing vessel and a tanker collided. The tanker owner conducted an internal investigation into the cause of the accident to identify root cause and any appropriate corrective action or remedial measures. The investigation was not done under the direction of an attorney or in anticipation of litigation. It was done to comply with a treaty, and specifically the International Convention for Safety of Life at Sea of 1974, which, until researching this case, I did not know existed. After the investigation, the lobster vessel brought suit against the tanker owner and sought to depose the owner on its internal investigation and findings. The tanker owner moved for a protective order to avoid having to testify about its internal review, and it claimed that its analysis and conclusions were protected under the self-critical analysis privilege, even though no attorneys were involved. And the question is there such a thing? And the answer is maybe. This example is from a case out of federal court in Massachusetts. And the court in that case held that the investigation was privileged, even though it didn't involve any actual attorneys, and was done for a mere compliance with the treaty obligation. The idea behind this privilege, in quotes, is that society wants to incentivize companies to be proactive about improving health and safety and investigating and fixing potential shortcomings. If the conclusions from those investigations were subject to disclosure, it might have a chilling effect on companies' willingness to do proactive investigations. So the courts that recognize the privilege have settled on a compromised position. The facts underlying the investigation are not privileged, but the company's conclusions, opinions, or subjective impressions are privileged and do not have to be disclosed. There are 4 main factors to consider if you want to see whether the self-critical analysis privilege might apply. The first is the most obvious. Does the information come from a self-critical analysis that was undertaken by the company? Second, there has to be a strong public interest in ensuring the free flow of the type of information at issue, meaning the sort of self-critical information. Third, would disclosure of that information have a chilling effect on the willingness to undertake future investigations? And fourth, there has to have been an expectation that the information would remain confidential. If the company undertook an investigation and expected that the outcome of that investigation might be publicly available or wouldn't be confidential, then even if it is self-critical, the privilege may not apply because they didn't expect it to remain confidential. But be wary of relying on this privilege because it's still not very well established or widely recognized. If you want to maintain privilege over investigations, the best way to maintain that privilege is still, in our opinion, to have an attorney be involved in the investigation and have steps be done at the direction of the attorney to ensure that there is a privilege that applies. I'm now going to turn to some specific privilege scenarios that we've seen come up. The first scenario that we see quite frequently is employee email and communications between the employee and their own attorneys using their work email. For example, let's say disgruntled Dan was just notified that he's being let go by his company, Ethical Enterprise. Dan exchanges a series of emails with his personal attorney about the notice and his desire to sue Ethical Enterprise. Can Dan claim privilege over those emails to prevent Ethical Enterprise from reviewing them? The answer is maybe. Many people believe that the mere fact that an employee is using work email means that the employee has no right of privacy in those communications. But that's not strictly true. The general presumption is that the use of company email does not automatically destroy an employee's reasonable expectation of privacy. But some U.S. courts have held that company policies can destroy the expectation of privacy. This case out of Delaware is one example that outlines 4 factors to consider. If the company has a policy that prohibits personal use of company email and indicates that work email will be monitored and that the company may access that email, that may be enough to override the employee's expectation of privacy and to waive privilege over communications that might exist between that employee and his or her attorneys in the work email. Again, though, check your jurisdiction. Some courts put greater emphasis on the employee's expectation of privacy and the need to protect privilege than other jurisdictions do. You should also consider where the employees are located. Employees who are located in Europe, for example, may be subject to the GDPR, which has stronger protections over employees' information. However, in our experience, almost all companies nowadays have policies like this. And so the real key when you have these policies is making sure that employees are notified about these policies and aware. Because as you can see, if they're not aware, the fact that the policy exists may not be sufficient. Another frequent question is what happens to privileged communications when a company is sold or merges? Does the privilege pass to the purchaser? Well, it might. It depends on the type of transaction and what the end result will be. Generally, if the entire company is purchased by new owners, any pre-existing privileges will pass to those new owners. But that may not be the case if only part of the company is sold or transferred. All right. This first case out of Illinois, for example, it involved an asset purchase. And in that case, the purchase agreement expressly stated that all privileges were intended to transfer to the buyer. But despite that agreement and what was included, the court held that the privileges were waived and did not transfer as a result of the asset purchase. This second case, though, from bankruptcy court in Texas, reached a different outcome and approached the question in a more holistic manner. The court asked, from a practical perspective, what's the result of this transaction? If the company is going to continue in operation after the transaction and will just be under new management, then the privileges should extend in the court's view. And so they held in those circumstances the privilege passes, but if there's a change to the company or its operations that's more than just a mere change in ownership, the privilege may not pass. Now we're going to turn to the tips we promised we'd give you to help safeguard and identify privileged communications. These are a combination of takeaway points from what we've covered already today, and also practical guidance that we've identified from some of our past experiences. First are the tips for safeguarding or protecting privilege. And in this arena, the most important tip is to properly label privileged communication. As Kayla mentioned, the label is not dispositive, and the fact that you put an attorney-client privileged communication stamp on the document will not actually make it privileged. But that label is extremely helpful in ensuring that the communication is not overlooked and later inadvertently produced. It's also extremely helpful in the moment so that people who are engaging with that communication understand that this is a privileged communication that needs to be treated separately from other routine emails. In addition to labeling, and as Kayla mentioned earlier, we also recommend that you make the justification for the privilege explicit in the communication itself where possible. If you're an in-house attorney and you're responding to a request for guidance from one of your business people, put that in the email itself. State, Jeff, I'm responding to your request for guidance or legal advice on the following. This kind of contemporaneous statement bolsters the privilege claim because it shows that in the moment the parties intended and understood that this was a privileged communication. And it helps show, particularly later down the road in discovery, that this is not a privilege argument that's being made as a litigation posture. It was actually what was intended at the time, and as you can see in the email, it involves legal advice. A third tip for protecting privilege is to limit the disclosure of privileged communications, even within the company itself. In general, a corporate client, for privilege purposes, is the management of the company, the officers, directors, etc. That group is sometimes referred to as the control group. And when you forward a privileged communication to lower-level employees who are outside of that group, that risks a waiver of the privilege, unless those lower-level employees have a need to know that information. That sort of need to know would arise if the lower-level employee is involved in implementing or following the legal advice, and they need to be aware or know of the information in order to do that. We also recommend, as Kayla touched on, that in-house counsel segregate legal and business communications to the extent possible. Because many in-house counsel have dual roles, it's important to highlight when you're speaking in your legal capacity versus your business capacity. Some in-house counsel have multiple titles, vice president and general counsel, etc. You can potentially alter your email signatures accordingly, vice president when it's business advice or general counsel when it's legal advice. That's not required. It's just another step to consider or take to maintain that segregation between legal and business. Another part of the segregation should include avoiding long email chains where possible, or what we've put in this slide in bold as break the chain. If you send legal advice and someone responds to that advice with a question about the business implications of the advice, consider responding to the second question in a separate email, because now you've moved beyond the legal advice context and into the business context. But if you simply respond all in the same chain, you create a long email chain that includes an initial privileged communication at the very bottom, and then continues in each iteration of reply back and forth. That also risks the possibility that the communication will be disclosed beyond the control group, because the further away you get from that initial privileged communication, the less likely it is that someone will scroll through the entire chain and identify the privileged communication, and they may just forward it to lower-level employees thinking it's business advice when, in fact, it's a privileged communication. Our fifth tip for protecting privileged communications is a general guidance rule to avoid being overly aggressive with privileged claims during discovery. In our experience, over-inclusion increases skepticism over stronger, more important claims. So when you're thinking about privilege, and this extends to when you're labeling communications, for example, ask yourself if disclosure would harm the company's interest in any significant way. And if not, consider whether you really need to identify that document as privileged or reserve that designation for a stronger claim where disclosure would really harm the company's interests. Our last topic are tips for improving your privilege reviews. And we touch on this because privilege reviews are really where most privileged communications are identified and withheld before being produced to the other side in discovery, for example. Our first tip is something that comes up a lot, and that is to maintain an up-to-date counsel list. The starting point for most privilege reviews is to identify and segregate all communications involving a lawyer. Communications with outside counsel, for example, are often identified by searching for all communications to or from a law firm domain name like @hushblackwell.com. But if a law firm merges, which happens frequently in today's world, and its domain name changes, that information needs to be identified in the searching process so that we can account for it in the privilege review and modify searches accordingly. Because a search for @hushblackwell.com, for example, will not identify emails to or from @hush.com or @hb.com. And those may be privileged, and so maintaining the up-to-date counsel list will help ensure that all of that can be accounted for in those searches. A corollary to the updated counsel list is to refer to attorneys by their full names, or at least avoid using only common first names, such as Jim or Steve. This aids the review process and makes it easier to identify privileged communications that may not have been labeled. For example, an email that says, "I just spoke to Steve and he thinks we should preserve our emails and hire an expert," could be overlooked because the reviewer may not know that Steve is an attorney giving legal advice. A better approach is to refer to Steve Neely or Steve N or even Steve from HB, all of which give a clearer indication that Steve is an attorney and that the advice that's being discussed is legal advice. The third tip for privilege reviews is a repeat, and that is break the email chain. We frequently see email chains that have a single initial privileged email and then multiple subsequent non-privileged emails as part of the chain. These long chains result in extra redaction times and costs because the initial privileged email would need to be redacted and logged, but the rest of the email chain is relevant and needs to be produced. These long email chains also create the risk of an inadvertent disclosure even in the discovery context because the initial privileged email is low down in the chain, and with multiple copies of that change, there's a risk that it might be overlooked. If you break the email chain, it helps segregate the privileged communication, and it reduces those risks and the costs associated with redaction. It also helps to remember that the result of any privilege review is a privilege log. It can be tempting to adopt a liberal review of privilege for the first review and just have the mindset that you'll really make the privilege determination if and when the other side challenges it. This approach can result in needing to do multiple reviews of the same documents, and it increases costs unnecessarily. It can also result in a waiver of the privilege in some circumstances. This case here out of the Southern District of New York is a fairly egregious example, but it's instructive. In this case, Deutsche Bank took an aggressive initial approach with its log. It simply put a lot of documents on the privilege log and then later went back and looked at its determination when the other side challenged. And what they found many times was that their initial privilege determination was unfounded. The court initially got fed up with this approach, ordered Deutsche Bank to go back and revisit all of its privilege designations, which Deutsche Bank did not do. And as a result, the court held that they waived the privilege over the documents that remained on their privilege log because, as you can see in the quote, the privilege log is not just a mere administrative exercise, it's something very serious that needs to reflect well thought out and supported privilege determination. Our final tip for privilege reviews is to get a 502D order when you're in litigation. And this refers to Rule 502D of the Federal Rules of Evidence, which provides that a court may issue an order stating that the disclosure of privileged information does not waive privilege, regardless of whether the disclosure was inadvertent. And the protection remains in place both for that litigation where the order is entered, as well as any federal or state proceeding that follows. Having a 502D order reduces the risk associated with inadvertent disclosure of privileged information because it allows you to call the information back in virtually any circumstance. This can be particularly beneficial in very large cases where it's impractical to do a privilege review of a very large document volume, so you can move forward with productions and claw back privileged information when you identify it. That brings us to the end of our presentation. Unless we have questions from the audience, I don't think we do. So thank you for joining us for our program today. If you do have questions, don't hesitate to contact either Kayla or myself. We hope the information that we've provided today was helpful for you and your organization. If you have not already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. As a reminder, this program has been approved for CLE credit in Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, and Texas. Virginia and Wisconsin credit is pending. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. This concludes our webinar. Thank you.